A new filing today in United States versus Trump, Waltin Nada and Carlos de Oliveira in the Mar-a-Lago documents case down in the Southern District of Florida. This is called the Second Joint Discovery Report. This is filed by Jack Smith's office, the special counsel, and it says with the court's order of November 10th, 2023, which is electronic case file number 215, which we're going to refer to in a minute, the United States of America files this discovery report. What does this mean? It means that both parties under Federal Rule 16 are required to turn over discovery. What is discovery? Discovery could be lots of things. It's anything that they are going to use at trial in addition to other relevant information. So I'll just talk about Rule 16 of the Federal Rules of Criminal Procedure. The government is required to disclose any statements of the defendant that he has made or she that has, whether it's oral or in writing, before or after arrest, whether it's interrogation or otherwise. But any statement that the government intends to utilize at trial that was given to the government, meaning a statement made to a government agent. Any defendant's written or recorded statement, they have to tell the defendant whether they have any, make them available for inspection, copying, photographing. Any relevant written or recorded statement by the defendant, if it's in the government's possession, custody, or control, or they know through due diligence they could get that statement. And it continues to go on. Any statement made by the defendant in front of the grand jury, they have to, in the charged case, they have to provide that statement as well. If it's the defendant's an organization, there's other documents that have to be turned over. That's also in Rule 16. The defendant's prior record, any documents, objects that the government would like to introduce at trial, and they have to let the defendant inspect, photograph, copy, whatever, any books, papers, documents, data, photographs, tangible objects, buildings or places, or copies or portions of any of these items if the item is within the government's possession, custody, and control, and the item is material to preparing the defense. The government intends to use the item in its case in chief at trial, or the item was obtained from or belongs to the defendant. Goes on to then list any reports or examinations or tests that the government is in possession of, whether it's a scientific test, physical, mental examination, etc. If there's a result or a report that the government either has, could get, and is either material to preparing the defense or the government intends to use it in trial, that has to be turned over. Any expert witnesses, there's a duty to disclose any experts that the government intends to utilize, including including any reports or anything that they are going to utilize in their testimony. And then the time for disclosure has to be, the court sets it by local rule, and that's relevant here. So there's other disclosure obligations such as grand jury transcripts and things like Brady, which is anything that tends to exculpate a defendant or goes to his innocence or could impeach one of the government's witnesses, things like that. So discovery is really anything that's related to the case, not just things that you're introducing into evidence, but anything that could help the defense prepare for trial or help the defense because it somehow tends to support their position, et cetera. So it's usually very, very voluminous on the government side because you basically turn over your whole file except for any work product. You don't have to give over your work product, like your notes, your internal memos, etc. So there is, though, also an obligation for the defendant to disclose under Rule 16. It's Rule 16B, and under Rule 16, actually 1B, under Rule 16 1B, the defendant's disclosure, they have to turn over items as well to the government. Thank you very much. I hesitate because we were the people of the state of New York, but the United States is the government. Anyway, so anything that the defendant must permit the government to photograph, copy, etc. Anything that is in the defendant's possession and the defendant intends to use at their case in chief at trial, meaning any evidence or anything that they are going to put on if they are going to put on a case. The defense doesn't have to put on a case. The government has the sole burden of proof. The defense in any criminal case doesn't have to put on a case. They don't have to testify. They don't even have to cross-examine witnesses or open or close. The government has to meet their burden beyond a reasonable doubt of each and every element of each and every crime against each and every defendant. And there's no obligation for the defense to do anything. But if they choose to put on a case, meaning not just cross-examine, but to actually put evidence on, then they have to disclose papers and books and documents and data and photographs and tangible objects, etc. They also have to turn over to the government any reports or examinations or tests that they are intending to introduce at trial, like let's say they have their own experts, their own DNA tests, their own drug tests, whatever the case may be, and any expert witnesses that they intend to call at trial. And it's the same time period, meaning that the court sets by local rule when these things have to be turned over. Now, this is obviously much more complicated than I am saying, but you get the idea of what it is and what the obligations are and who has to turn what over. So in ECF number 215, which is the docket entry in the Florida case, the Mar-a-Lago documents case in front of Judge Eileen Cannon, this is where she updated the time period for the schedule of the case, because there was a superseding indictment where they added Mr. Defendant de Oliveira, or they have more discovery than originally thought. And so Judge Cannon gave an initial schedule for the trial, but then she decided to change that, which she did in this entry. And this was filed on November 10th, 2023. And her schedule that she set out for things, including discovery by both parties, was that by today, meaning January 9th, 2024, a joint discovery status report was required to be submitted, meaning it's something that both parties would agree. It's a status report on where they are with discovery. You have to file, how's it going and what have you done? And both parties, since it's a joint discovery report, is required. She anticipates both parties to have discovery done and to tell her how it's going. Both sides require a demand for discovery, but that's pretty pro forma, and lawyers typically do that. But here, this second joint discovery report. So there was a first one with the first tranche of discovery. So the special counsel's office says, in accordance with the court's order of November 10th, 2023, the one we just discussed, the United States of America files this discovery report. The order contemplates a joint discovery report being filed, but as the defendants have yet to produce any discovery, the government has prepared this report. Do you hear this? This means that either Trump does not intend on putting on a defense at all, or they're not fulfilling their obligation and could be held in contempt ultimately, or precluded from presenting certain evidence at trial for failure to comply with discovery. I have my own theory why Trump isn't turning over any evidence or any discovery that they intend to use, because he doesn't ever expect there to be a trial. Why doesn't he expect there to be a trial? Because he doesn't want a trial. He wants to delay this case. hopefully in his own head become elected, and then dismiss the case through whoever he appoints to be the head of the Department of Justice, and then pardon himself and Waltin Nauta and Carlos de Oliveira. That is his grand plan. So he doesn't plan on presenting any evidence because he doesn't plan on there being a trial. And it certainly seems like Judge Cannon is going to allow him to delay this because she keeps giving more time for various things that don't require more time. And certainly she, as others have said, this is a game of inches that Trump is playing, because any adjournment, any extra time, any few days, whatever it is, if he could just inch closer to the election, then he will, his master plan of never having a trial he will have succeeded, because there is internal policy at the Department of Justice that no case can interfere with the political process or an election. So if you get too close to an election, then they actually won't try the case. And so let's see what Judge Cannon does. But as of now, the government has made 8 productions of unclassified discovery, as well as other discovery for classified documents. They've produced over 1.28 million pages of unclassified documents and over 4,000 pages I think it was 2,600 pages of classified documents. So there's lots and lots of documents and video and other discovery that they are turning over, and they are complying with their obligations, of course, but Trump is not. So that's what's happening. Let's see if Judge Cannon will hold the defendants' feet to the fire and make them comply with their discovery obligations if they plan on presenting a case, if this case ever goes to trial. And hopefully it will. I'm Karen Friedman Agnifilo with Legal AF. Join us every Wednesday and Saturday.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.